The public protector also found that the president, as a presidential candidate of the ANC, had received campaign donations which benefited him in his personal capacity, and that his failure to declare those donations constituted a breach of the code. Once more, the evidence on record showed that the president did not personally benefit from the donations made to the CR17 campaign. The public protector may have not believed it, but she did not reject such evidence. Consequently, the matter must have been decided on the basis of that evidence. But more importantly, both these issues did not form part of any of the complaints submitted to the public protector. Therefore, she did not have the authority to investigate matters falling outside the complaints. This is a requirement of Sections 3 and 4 of the Act that empowers the public protector to investigate violations of the code. I shall move to the next finding: competence to investigate the affairs of the CR17 campaign. The public protector and the EFF argued that the High Court erred in concluding that the public protector had no jurisdiction over the CR17 campaign. The public protector contended that the source of her powers is Section 182 of the Constitution, together with Section 6 of the Public Protector Act. The EFF submitted that internal party elections constitute state affair because those party elections are a step towards legislative bodies. There is no merit in the argument advanced by both parties. Both the Constitution and the Public Protector Act do not empower the Public Protector to investigate private affairs of political parties. Political parties do not perform a public function or exercise a public power when they conduct internal elections. Theirs is a private affair and not a state affair. Moving to the investigation over the suspicion of money laundering. The public protector found that the 500,000 donation from the CEO of African Global Operations passed through several intermediaries, and this raised a suspicion of money laundering. But the evidence placed before her dispelled all this. The donation passed through only one account and not several intermediaries. The president complained that the interim report in respect of which he was afforded the opportunity to make representations did not include the remedial action. He contended that he was entitled to a hearing before the decision on the remedial action was taken. The public protector countered this argument by submitting that Section 7, Sub 9 of the Public Protector Act obliges her to afford the affected persons a hearing only during an investigation. On a proper reading of Section 7, Sub 9, we concluded that a person against whom remedial action is taken is entitled to be heard on the proposed remedial action. We also held that the public protector had no authority to make the remedial action she had issued against the Speaker of the National Assembly. In a dissenting judgment, Mkhwebane CJ concludes that Mr. Mkhwebane lodged a formal complaint that allowed the public protector to investigate every aspect of the president's CR17 related conduct that she considered as potentially unethical. He holds that financial assistance from individual donors and even the composite amount from the CR17 campaign as an entity constitute a personal benefit to the president and creates a situation that involves a risk of conflict between the president's private interests, his pursuit of the ANC presidency with the assistance of private donors, and his official responsibilities as Deputy President of the Republic member of parliament, leader of government business in parliament, and even as president of the republic. The president should, in his view, while still a member of parliament and deputy president, have disclosed the sponsorship to the National Assembly as enjoined by the Constitution, the Members Act, and the Code. He further holds that the emails which the president effectively admits are authentic, true, and reveal that he deliberately represented a falsehood to the public protector. And this, together with his failure to disclose the private donations to his campaign, run against the very essence of his obligations laid out in sections 96 sub 2b, 83b, and 181 sub 3 of the Constitution, and the values of transparency, accountability, on which our democratic state was founded. In the result, the following order is made. 1, leave to appeal is granted. 2, save to the extent mentioned below, the appeal is dismissed. 3, the dismissal of Mkhwebane's Center for Investigative Journalism, NPC's claim for constitutional invalidity of the Executive Ethics Code is set aside. 4, the matter is remitted to the High Court for determination of that claim. 5, the President of the Republic of South Africa is ordered to pay costs of Mkhwebane Center for Investigative Journalism in this court, including costs of 2 counsel. 6, no order as to costs is made in respect of the other parties, including freedom under law. I hand down the judgment.